Feisty Quickie. So where is the edge between what can be copyrighted and what cannot? The Copyright Office has confirmed that the output of an algorithm cannot be copyrighted because it lacks human creative input. But how is that going to apply to generative AI? The Supreme Court considered the presence of creativity as a requirement for copyright back in 1991 with Feist Publications v. Rural Telephone Service. Rural was a monopoly phone utility in northwest Kansas, and like all phone companies, they published a phone directory with white pages and yellow pages. Zoomers, ask your parents. Feist was a publishing company making area-wide telephone directories, not just local to the resident's calling area. They licensed the phone listing from 11 other telephone companies, but Rural refused. So, Feist used them without permission, and Rural sued for copyright infringement. The Supreme Court noted that, while facts themselves could not be copyrighted, compilations of facts could. Think about the Farmer's Almanac. Again, Zoomers, ask your parents. The problem was, as Sandra Day O'Connor wrote for the unanimous court, common sense tells us that 100 uncopyrightable facts do not magically change their status when gathered together in one place. So what made the difference? Quote, "The sine qua non of copyright is originality. To qualify for copyright protection, a work must be original to the author. Original, as the term is used in copyright, means only that the work was independently created by the author as opposed to copied from other works, and that it possesses at least some minimal degree of creativity. To be sure, the requisite level of creativity is extremely low. Even a slight amount will suffice." The problem is, there's no creativity in a phone book. Quote, "The standard of originality is low, but it does exist. Rural simply takes the data provided by its subscribers and lists it alphabetically by surname. The end product is a garden variety white pages directory devoid of even the slightest trace of creativity." She also refuted what a lot of artists assert, a sort of labor theory of copyright. Quote, "It may seem unfair that much of the fruit of the compiler's labor may be used by others without compensation. However, this is not some unforeseen byproduct of a statutory scheme. It is, rather, the essence of copyright and a constitutional requirement. The primary objective of copyright is not to reward the labor of authors, but to promote the progress of science and useful arts. To this end, copyright assures authors the right to their original expression, but encourages others to build freely upon the ideas and information conveyed by a work." And the competing phone book wasn't infringing because, quote, "Assuming the absence of original written expression, only the compiler's selection and arrangement may be protected. The raw facts may be copied at will. This result is neither unfair nor unfortunate. It is the means by which copyright advances the progress of science and art." So putting even a slight amount of originality into the prompts or whatever can transform the output of the algorithm to a copyrighted work. No doubt there will be court cases about where that line is drawn, but they'll be based on this.